there's a lot of questions around flexibility, or perhaps the lack of flexibility related to an irrevocable trust. People think that often when you set up an irrevocable trust, it's very rigid, it's not flexible. And today I want to talk about one particular item related to that, and that's whether or not you can change the name of an irrevocable trust. So let's get into it. All right, with an irrevocable trust, there is this question specific to whether or not the name of a trust, an irrevocable trust, can be changed. And there could be a few different reasons why you want to accomplish this. It could just be an administrative reason. Maybe the name of a trust is really, really long, and for a multitude of reasons, it's cumbersome to have this very lengthy name. So maybe you want to change it. Maybe you want to shorten it. Or it could be a matter of privacy. So often people are setting up irrevocable trusts for purposes of privacy. They want that trust to hold assets rather than in their individual name, and that irrevocable trust will provide them asset protection and it will provide them privacy. So there could be a situation where that irrevocable trust does become part of public eye. Maybe there's a lawsuit against it. Maybe that trust is entered into a lot of different transactions that are public transactions. And so this trust name is a matter of public domain because of that. Now, there is this ability under South Dakota law to change the name of an irrevocable trust. I want to mention that, to my knowledge, there aren't states that also have this law on the books. Now, it could be that they do, and I just don't know, but I do know that South Dakota, along with its other flexible laws around asset protection, privacy, control, etc., they have a law that states that a trustee, if they think it's in the best interest of the trust, has the ability to change the name of the trust. And as I said, this could be really, really important related to privacy, which directly impacts asset protection. So if for some reason there is a situation where, let's say, the trustee has become publicly known, the name of the trust has become publicly known, that could compromise the asset protection. It could make the trustee, a target for frivolous lawsuits. And being able to change the trustee and then also change the name of the trust could be significant when it comes to maintaining ongoing privacy, ongoing asset protection, and getting a target off your back. So if you ever do need to change the name of a trust, let's say you set up a trust in California or Texas or Florida, or in a state that doesn't allow you to change the name of the trust, of, again, the irrevocable trust, what you can do is re-domicile this trust to South Dakota. Now, that can be done a few different ways. It could be done through a trustee. It could be done through a trust protector. Each trust is going to be a little different, but the point is you can take a trust from another jurisdiction and move it to a trust, to a jurisdiction like South Dakota, and then it be governed according to South Dakota law. And once that happens, you start to have that flexibility to be able to decant a trust or add beneficiaries or remove beneficiaries or limit the amount of information that is shared with beneficiaries. Or, as we're talking about in this video, you can change the name of the trust. So just one more reason that South Dakota is better than Nevada, Wyoming, Delaware, Alaska, etc., and other trust jurisdictions.